I'm Drew Stevenson, and this is a lecture about the classic Supreme Court case, Skidmore v. Swift and Company from 1944. This is about judicial review or judicial deference to agency statutory interpretation or agency interpretations of their governing statutes or the statutes that they are supposed to implement. Now, a quick word for my students about this case. This is a very important case in administrative law. In the administrative law casebook I use, it's not kind of featured as one of the lead cases, but it's discussed extensively in the notes, and some of the most important cases in the course, like Chevron and Mead, discuss Skidmore. It is a lead case in my legislation and regulation casebook. And it probably should be, because we still have a doctrine of Skidmore deference. We still talk about the Skidmore factors to this day. So this is good law. It applies when Chevron doesn't. And it's important to at least know the case by name, a little bit about what it was about, and especially the factors that the court rolls out at the end of the case. So let's take a look. So the Swift and Company was a really large nationwide meat packing company in the early and mid 20th century. They had plants all over the place. This is actually about some of their meat packing plants in Texas. And they had these large facilities, large enough that they had to have their own firefighters on location for when fires broke out. And so that's who is the plaintiffs in this case. One little confusing note for my students: keep in mind, neither Skidmore nor Swift are administrators, right? So this starts as a private dispute between employees and an employer, and the agency intervenes in the case, filing an amicus brief. So these firefighters worked at a meatpacking plant and were paid a weekly salary for working their regular shifts. But they also all had to stay overnight on the premises a few nights a week. They took turns, so that there was at least a skeleton crew of firemen there during the night shift in case a fire started. Now, during that time, of course, most of the time there's not going to be a fire. So they had a pool table, they would play cards, they could listen to the radio, they could sleep, they had sleeping quarters and so forth. So they could really use the time as they wanted. They just had to be at the facility in case a fire started. The firefighters said that the time they spent in the building after hours should count as work time. After all, they couldn't be at home or doing things that they wanted to do outside the facility. And so that should entitle them to overtime pay, which is time and a half, under the Fair Labor Standards Act, or FLSA. Now, please note, the FLSA doesn't really spell out an administrative agency that is supposed to adjudicate disputes in it, unlike most of our other labor statutes. But there is an agency called the Office of the Wages and Hours Administrator within the Department of Labor, and they have investigatory powers and can bring injunctive actions. So sort of prosecutorial, they do investigation and then bring enforcement actions, even though they don't do any adjudication or real rulemaking, to restrain violations of the FLSA. And the administrator's office issues its views of the law in interpretive guides and informal rulings. So these aren't really promulgated regulations, but it's their approach to bringing enforcement actions and how they're interpreting the law. Now, the trial court in this case, in Skidmore v. Swift and Company, sided with the employer, with Swift, on the grounds that engaging in such pleasurable occupations like hanging out playing pool and dominoes does not constitute work as a matter of law, so they shouldn't have to be paid, these firefighters shouldn't have to be paid for that, even if they were stuck on company grounds at the time. Now, the administrator disagreed with this. Remember, this is the person within the Department of Labor that enforces the wage and hours rules. And he called for a flexible approach. That he said that waiting time sometimes counts as working time and sometimes not. The administrator submitted an amicus brief saying that the time the firefighters spend eating should not count as work time, but the time that they're truly waiting for an alarm should count. right? So normally you wouldn't be paid during your lunch break or dinner break. So the rationale was, we don't have to pay you during your meal time, but the rest of the time that you're sitting there, even if you do get to play dominoes and pool and listen to the radio or sleep, at any moment you could have to spring into action and put out a fire. So the question, this goes to the US Supreme Court. And the question for the Supreme Court was whether the waiting time could ever count as work time within the meaning of the Fair Labor Standards Act. So we have a statute, and the parties are asking the courts to decide, but the agency that basically enforces the statute is asking the court to interpret it a particular way, and they weren't a party to the case. This will come back to haunt us. There will be echoes of this in later decisions like Our v. Robbins, by the way. And so on the question of whether waiting time can ever count as working time under the FLSA, the Supreme Court actually agreed with the administrator that it can, but they at least said they're not doing it out of any sense of deference to the administrator. Rather, the court resolved this issue, or at least claimed to, de novo, like they did in the Hearst case, and then remanded it. And on remand, the trial court was supposed to determine whether this specific waiting time should count as working time within the meaning of the FLSA. So the court interpreted the statute, remanded it to the trial court to do a little bit more fact finding, and then make its determination according to within the parameters that they set. The way the court talks about this makes it sound like a mixed question of law and fact. Again, echoes of NLRB v. Hearst. Even so, now we're getting to the holding of the court of the case, and the part that as a student you really care about. The court does not instruct the trial court on remand that it should give the administrator's opinions substantial deference under the Hearst standard. So here we are in the 1940s. This is actually right after the Hearst decision. They're saying in Hearst said, we give a lot of deference to the agency's findings of fact in cases. And here they're saying you don't even have to give that. And this is the most important feature of this of Skidmore to remember. Skidmore is not Hearst. Skidmore is its own standard of deference, level of deference. So the administrators, and keep in mind, the administrators' interpretations here don't have the force of law. They're not binding. They're more like interpretive rules or enforcement policies like that a prosecutor's office might adopt or the Department of Justice might adopt than legislative rules. They're not promulgating codified regulations. They're putting out guidance documents about what they consider a violation and when they might consider bringing an enforcement action. And so even though the court does not think Hearst deference is appropriate, the court also does not call for de novo review by the courts. In other words, the courts don't get to just make up their own minds and decide every case for themselves. And for my students, if this is starting to get confusing, welcome to this part of administrative law. We have several different types of deference. We have Hearst deference, Skidmore deference, Chevron deference, Auer deference, on, and each of them are a little bit different and apply in different situations. And here we're going to learn about Skidmore deference. So the opinion says that the agency's interpretations are entitled to respect. So they call it respect as opposed to saying deference. You don't have to defer to the agency and basically just accept what they say, but you should give it a lot of weight. And especially considering the agency's expertise and experience. And I'm going to come back to that point later. That seems to be an additional Skidmore factor, is how much expertise and experience does the agency have, but that's almost always going to be a factor when the agency is asking for Skidmore deference. The amount of weight given to the agency's views, assuming they have expertise and experience, depends on several factors, including the thoroughness evident in its consideration, these are quotes, the validity of its reasoning, the consistency of the agency's interpretation with other pronouncements, and so forth. And these, if I can distill them for you or paraphrase a little bit, are the Skidmore factors. So you might want to pause for the video for a second. These are the big takeaway from the case that you should really remember. So we're looking at, first of all, how what is the thoroughness of the agency's consideration? How long did the agency study it? How much did they document their studies? Did they have lots of meetings and do lots of scientific studies? Did they spend a week talking about it at the office, or did they spend a year investigating it and coming up with the perfect rule? The validity of its reasoning, so its overall reasonableness, right? Is the agency, it doesn't matter how long they spent if they came up with something crazy. Also, the consistency of the agency's position over time, and that we're going to have that as an issue in other places in the course too. But basically, is the agency changing it completely, doing an about face every time, let's say in every case, based on how much they like the parties, or every time a different party wins the White House? Or has the agency been using the same rule or the same interpretation of the statute for decades, in which case people are kind of on notice of this, and they've had a chance to see how it works in practice and so forth. Please note that this is very important. The Skidmore factors are not exclusive, because their last one is any other factors that make the agency's interpretation persuasive, like the agency's expertise or the private interests at stake in the case and things like that. So there could be other factors, but we have three that it delineates clearly. How in depth was the agency's study and review? How much time and energy did they spend on this? How valid is its conclusion? And how consistent is this with the agency's historical kind of track record? Or are they doing something out of the blue, which makes the courts kind of wary? Now, tying this together with the Hearst decision that came out in the same era, on pure questions of law, a court will decide the issue itself without any deference, or at least without very much deference and maybe without any reference to the agency's view. So the courts feel very qualified to interpret pure questions of law, like what does the statute say, and so forth. And so they don't have to care what the agency says. So about things like, do we have jurisdiction? What does the Constitution mean? And so forth. Now, what about on mixed questions of law and fact, where the agency has been entrusted by Congress with the power to issue binding rulings and has done so with assuming proper procedures that they followed? A court should then defer to the agency if its conclusion is reasonable and based on the record and relevant law. And then on mixed questions where the agency can only issue non-binding interpretations, which is the case in Skidmore v. Swift, we don't have an agency that can promulgate regulations that have the force of law, but they can sort of announce their enforcement policies, who they're going to go after, or which cases they prioritize, what they consider a violation, and what things are safe harbor provisions, and so forth. And in that case, an agency's views are entitled to what this court calls special respect due to the agency's expertise and experience. But ultimately, a court does get to decide what it thinks the right answer is. So if it thinks the agency is just dead wrong, then that goes to the validity of its reasoning. One final quick note. So my students, if you're a law student, you need to connect this with two other very important cases. Skidmore was the law of the land for judicial deference to agency interpretations of statutes, basically, until Chevron in 1984. So from 1944 to 1984. In general, courts applied the Skidmore factors, but there's a little bit of a difference, as we'll see, because remember, then Chevron, it was something that had the force of law. Even today, in cases of agency interpretation where Chevron does not apply, and after the Meade decision, we call this Chevron step 0. Just a quick aside, that's when we have situations very similar to the Skidmore case, where the agency is issuing maybe guidance documents or something like that, but not promulgating regulations that have the force of law. Then Skidmore to this day is what courts fall back on. In other words, if we're applying Meade, if at Chevron step 0, we decide that Chevron doesn't really apply, we're probably then going to switch back to applying Skidmore deference. Also, little point of trivia, Justice Stevens, who wrote the the Chevron decision in 1984, often said that he was merely restating existing law. So it seems like he thought that he was encapsulating the Skidmore factors down into a two-step test. Okay, here's a quick review question to see if you've been paying attention. Under Skidmore deference, which of the following is not one of the factors courts weigh in deciding whether to accept an agency's interpretation of a statute? A, the thoroughness evident in the agency's consideration. B, how emphatic the agency is that its position is correct. C, consistency of the agency's position over time. Or D, the validity of its reasoning. Now, hopefully you know the answer to that. If you don't, then you really need to go back and watch the video again. And that concludes our lecture about Skidmore v. Swift and Company.